Hello, everyone. Welcome to the Don Lemon Show. This is an emergency broadcast. It is breaking news. In a 6-3 decision along ideological lines, the Supreme Court has a really big ruling. The former president, Trump, is entitled to blanket immunity from federal prosecution for, quote, official actions that he took while in office, but not for unofficial acts. We'll have to figure out what that means. You see, Melissa Murray is there. I'm going to introduce her in a minute. Suffice to say, this is a landmark ruling, one that not only has major implications for Donald Trump's legal entanglements, but also for every future commander-in-chief who sits in the Oval Office. This is huge. So to break it all down, I'm joined by the perfect returning guest, my friend Melissa Murray. She is the Stokes Professor of Law at NYU Law School, the co-host of the Strict Scrutiny podcast, an MSNBC contributor, and she is a former clerk for Sonia Sotomayor. Melissa, thank you. Can you break this down? What does this mean? What is absolute immunity from official acts, but not for unofficial acts? What does that mean?
Well, first, Don, thanks for having me. And I think it's worthwhile to sort of just explain what Donald Trump was asking for when he went to the Supreme Court with this argument. He was essentially arguing for what is a completely novel form of presidential immunity that would shield him from criminal exposure for any official acts taken as president. So he wanted sort of a broad-based immunity, saying that anything he did because he was president, including ordering his subordinates to engage in illegal actions like assassinating a rival, for example, those were all outside of the scope of criminal liability. He could never face criminal charges for that. And to be clear, the court kind of sort of endorsed that. They were very explicit that they weren't giving the president a blanket grant of immunity, but they came really, really close. So in this 6-3 opinion authored by the Chief Justice, and it lined up on very predictable ideological lines with all of the conservatives joining the Chief Justice's opinion for the most part. Justice Barrett joined for almost all of it, but not quite all of the Chief Justice's opinion. And then the 3 liberal justices dissented. But here's the TLDR. The court divided up the universe of actions that a president could take into 3 buckets. In the first bucket are those actions that are specifically authorized to the president under the Constitution. So these are what the court calls conclusive and preclusive constitutional authority acts. For those kinds of acts which the Constitution specifies and gives the authority to conduct to the president is entitled to absolute immunity from criminal prosecution. So you can't prosecute the president if he does something that is specifically outlined in Article 3. So if the president says, this proceeds under my duties as commander-in-chief, do. If this proceeds under my duties to take care that the laws are enforced, presumptively okay. Then there's a third category. I'm going to get to the middle category in a minute. The third category that's sort of clear and stark for the court are these private acts. These are private acts that the court says are wholly outside of the scope of the president's authority as a public official. Those are not immunized. So you have these things that the Constitution gives to the president, totally immunized. These things that are wholly private, completely available for prosecution. They're not immunized. Then there's this huge swath of actions that are in the middle that may not necessarily be clearly demarcated by the Constitution, but might nonetheless be in the outer perimeter of the president's official duties. And the real question is, what falls into that bucket? Because in that bucket, which I think is vast, the court has said that the president has a presumption of official immunity. So in those circumstances where there are activities or actions that are in the outer perimeter of his official duties, there is a presumption of complete immunity. And if the government wants to counter that, they have to present evidence that completely rebuts that presumption. And so all of the action going forward is going to be in that middle category, or fighting over what's in the first category, what the Constitution permits, and then what is in the outer perimeter of these official actions. I don't think we're going to hear a lot of discussion about what's private, because the court essentially says actions that we might think of as private, if they are conducted with someone who is within the president's official duties, like say the vice president, well, that might convert it into an official action and make it presumptively immunized. So one of the things the court talks about here is the part of the indictment where Jack Smith alleges that Donald Trump tried to pressure Vice President Mike Pence to submit a false slate of electors to disrupt the certification of the Electoral College. that would seem to be a wholly private act. But the court says when you're thinking about that, you can't think about what the president's motives are. You have to only think about whether it's something that's official. And if it's done with someone like the vice president, who has an official role and is an official in the executive branch, well, then it is presumptively official conduct and it is presumptively immunized. So the court has essentially made quite a lot of conduct presumptively immune from prosecution, and has basically given the president a lot of authority to do a lot of criming.
Is it? I'm glad you said that, because that's where I'm going. Does this fundamentally alter the nature of American democracy? Does it grant,
Yes.
an American
Yes.
president power that's akin to emperors or kings or, people who are not elected officials?
That is certainly something the dissent said. Justice Sotomayor said so very forcefully and read her dissent from the bench. As a matter of constitutional design, our framers were ardently worried about the consolidation of power in
Melissa,
any government.
can you hold that thought? Let me read that, because I think it'll help, and then you can say what you're saying. This is what that Justice Sonia Sotomayor, her dissent says this. This is what she writes. She said, the president of the United States is the most powerful person in the country and possibly the world. When he uses his official powers in any way under the majority's reasoning, he now, will be insulated from criminal prosecution. Orders a Navy SEAL Team 6 to assassinate a political rival, immune. Organizes a military coup to hold onto power, immune. Takes a bribe in exchange for a pardon, immune. I mean, that she's asking, is he immune to anything, right? And his orders, even if it's something that's wrong, even something that can be able to put an end to us. You know what I'm saying?
No, I think she's right. And there's another part of the opinion, of the majority's opinion, that Justice Sotomayor really took issue with, and I want to call attention to that. In addition to basically giving the president a wide swath of activity that falls into this category of official acts, constitutional acts, or acts that are in the outer perimeter of the president's official duties, the court also said that in circumstances where there is official conduct that is immunized, you cannot use the fact of those actions as evidence to establish the fact of other crimes or other activities the president has undertaken that are not immunized from prosecution. So if there are private actions for which the president can be prosecuted, you cannot use the fact of the official actions to establish or serve as evidence to establish those other acts that are not immunized. And Justice Sotomayor said, you're basically closing down every avenue. You've immunized him from a wide swath of activity, and even for the conduct that you presumptively have made him available to be prosecuted for, you've shut down a lot of the avenues that a prosecutor might have to establish that case. So you're hamstringing the government from ever holding a president to account. That doesn't look like a president. That looks like a king. And she talked about the history of our Constitution and the fears that animated the system of constitutional design that we have. We had framers who were worried about a parliament that had consolidated power and was too powerful, and a king that had done the same thing. And so they were trying to divide power up such that no one branch could become too powerful, could consolidate too much power and run roughshod over the others. What it seems like they didn't contemplate was the judiciary, which our framers thought of as the least dangerous branch, arrogating a lot of power to itself to say what the powers of the other branches are, and in doing so, allowing the court to be an imperial court that has essentially created and constructed an imperial presidency.
I think the question that everyone wants to know really is what then does this mean for January 6th, right? And then the other thing is who gets to decide what's an official act and who doesn't. But what does this mean for January 6th?
Well, in the short term, for January 6th, it doesn't really change much. This case had always, as a matter of de facto practicalities, had immunized Donald Trump already. The fact that the court took so long to issue this decision effectively meant that Donald Trump was not going to go to trial before the election for the events of January 6th. I don't think that has changed. What the court has done, though, is remanded this case and the indictment back to Judge Chutkin, the district court judge who's handling this trial, and she will have to go through the indictment and determine what actions were identified there that are clearly constitutional, clearly within the president's official duties under the Constitution. Those are off the table. Those are immunized. Then she has to decide and determine what are private actions. Those are subject to prosecution. And then she's going to have to decide that murky middle ground where there are activities that are in the outer perimeter of the president's official acts. Those are presumptively immunized, and it's up to the government then to rebut the presumption of immunity. And what's really interesting about this case, and one of the reasons why I think this is actually a very pro-Trump opinion, is that the court went through and looked and talked about all of the various allegations that Jack Smith made in the indictment and essentially talked about how you might think of those. Like, for example, I've already mentioned the Mike Pence issue. They have said that they think Mike Pence and the discussions with Mike Pence, those are official actions because it's a vice president talking to a president. They talk about the discussions with members of the Department of Justice. Like, for example, it's alleged that Donald Trump tried to pressure one of the members of the Department of Justice to step down or alternatively to declare that the election had been fraudulently conducted. According to this majority, that's not even presumptively immunized. It's fully immunized because the president has complete authority to direct the Department of Justice. He gets to tell the AGs what to do. So even if he's telling the AGs to do something that is unlawful, it is not something for which he can be prosecuted. So to the extent that Judge Chutkan has to make these determinations, the court has already laid out its view of how these decisions should be resolved. And if she departs from that, I think it's very clear that Donald Trump is going to go back and appeal and bring in this court's discussion of these particular allegations and how they would have resolved it.
I think this is what you're talking about, what Justice Roberts writes. The majority opinion has been overshadowed by the talk of assassinations and coups, okay? The president may discuss potential investigations and prosecutors with his attorney general and other Justice Department officials to carry out his constitutional duty to take care that laws be faithfully executed. So is Roberts, did he just declare the DOJ's independence dead in that offhand sentence? I mean, that sounds a little nuts to me.
I think it does sound nuts. I also think what's nuts here is sort of poo-pooing the public being worried about the prospect of coups or the assassination of political rivals. I think it's a very real consequence coming out of this decision. And I don't say that to be hyperbolic or to fearmonger. I think this is a decision that says that there are certain activities, like, for example, talking to your AG, directing your AG to do something that if you are president, that's your constitutional duty, and it can never be a crime when you do it, even if you're asking your attorney general to do something unlawful. That's wild. I mean, that's genuinely wild. It reminds me not of Donald Trump necessarily, but Richard Nixon, right? I mean, the whole idea that Richard Nixon during the Watergate debacle was telling his DOJ, the attorney general, solicitor general to do certain things that were presumptively illegal, and that he would, if he had not stepped down, would have been prosecuted for. And now the court is essentially saying, if the president does it, it can't be a crime. I mean, that's essentially what Richard Nixon once said. And poor Richard,
if the president does it, it's not a crime. He said that if the president does it, it's not a crime. My question is then, if the president, for any official act, if Joe Biden decides, because he wants to, or because enough people are saying it, that Donald Trump is a menace to society, is detrimental to American democracy, and therefore decides to do something about that, I'm not saying assassination, whatever, but to jail him or what have you, is that an official act and he can't be prosecuted for it?
Well, by the logic of this opinion, I think it would be. I think we'd also see the limits of this court's solicitude for presidential actions if Joe Biden were to do something like that. I mean, I'm being very opaque about it, but I'll say it straight up. This is a pro-Trump decision by a court that I think is very pro-Trump. I don't think we would have had this outcome if the defendant here had been a Joe Biden or a Barack Obama. If you look at some of the decisions the court has issued just in the last couple of days, last Friday, there was a decision on administrative agencies. At oral argument in that case, Brett Kavanaugh made a whole big, huge stink about whether the executive, the president, in working through administrative agencies and allowing administrative agencies to regulate in the name of the executive if it was outstripping the authority that Congress had delegated to the executive and to the agency. And he said, the agency cannot act like a king. The executive cannot act like a king. And yet, just 3 days later, we have a decision from this court that allows the president to act like a king. So essentially, you can direct the attorney general to commit a crime as president, but you cannot regulate smokestacks or particulate matter in air.
You're talking about Chevron deference, right?
Yeah.
The decision on Chevron deference.
I mean, the hypocrisy is utterly astounding, and the inconsistency of the logic is also astounding. I mean, I get to read all of these cases. I don't focus on just any one of them. We're looking at the whole term. And this is a court that has been really skeptical of the Biden administration when it's exercised executive power. Think about student loans. But now we have a court saying that executive power is vast and you can get your AG to commit crimes. You might even be able to assassinate a political rival. Who is to say? I mean, that's just like, again, sort of the lurches back and forth, depending on who is bringing the claim, is astounding.
Is there anything that is this is it, right? There's nothing that can be done about it. There's nothing the American people can do besides vote, which still they won't overturn the majority.
Well, I mean, let's not minimize that. The court wrote an opinion for the ages that will certainly authorize other presidents to do whatever they like. I think it's really incumbent on us to make sure when we're making our decisions about who will be the president, that we don't elect people who are going to abuse their authority, because this decision essentially means that there is an environment in which the abuse of authority not only will be accepted, but perhaps even rewarded. So it is absolutely incumbent when you make your decisions about who is going to be in the commander-in-chief chair that you're electing someone that you genuinely believe will not use the authority and trappings of that office for ill ends.
So I don't think people understand when I talk to people and they say, "Oh, I like Donald Trump because he gave me a check." Well, he didn't, because his name was on it. They feel that way. They're so overlooking the bigger, most important picture here, which
Well, I mean,
is
Don, to be clear, like, I'm not going to discount the stimulus. Like, lots of people actually benefit from the stimulus, got to start businesses. I will say, though, the stimulus would not have been necessary if the president had managed a clearly emerging health crisis in a more effective way. So yes, maybe the stimulus was a really popular jolt to the economy. It wouldn't have been necessary if this was an administration that believed in science, believed in expertise, and could manage an emerging crisis.
Yeah. Well, I mean, I agree with you. I mean, I'm not minimizing the importance of it, but actually it was a Democratic Congress that did it. He actually delayed it by putting his name on it, right? Like by holding it up to put his name on it. I'm just saying that this is a really important issues, and maybe we should be broader, or meaning the American people, in what we find is important, especially when it comes to, actually sustaining and having a democracy. So I don't know,
I think you're right. This is a very autocracy friendly opinion.
I am floored. I'm floored and flabbergasted because I was holding on until I spoke to you, holding on to the sort of, the divide there. Well, unofficial acts and official acts, but how do you actually, how do you decide between the two? Like, who gets to decide whether it's official or not official? And does that not official even mean anything, considering what the court has ruled?
Well, here's the best part. I said there were these three buckets. There's the stuff that's in the Constitution, that's presumptively immunized, or that's totally immunized, excuse me. And then there's the stuff that's sort of in the middle, in the outer perimeter, and that's presumptively immunized, and it's up to the government to rebut the presumption of immunity. And then there's the stuff that's private, and that's stuff that you can prosecute. At oral argument, Donald Trump's lawyer effectively said, listen, we're not seeking immunity for the purely private stuff. We're only sort of focused on the stuff that's official within the scope of the outer perimeter of the president's official duties. So to the extent that the court said, you know what, there isn't immunity for these private actions, he wasn't even asking for that. Right. So this isn't a situation where it's a partial win or a partial victory for Donald Trump. It is a full stop victory because they gave him everything he ultimately asked for, which is a broad array of conduct that the court now considers easily understandable and legible within the scope of his constitutional duties, and then another big bucket of conduct that might fall within the perimeter of his constitutional duties, and it's up to a court to find that to be presumptively immunized and then determine whether the government can rebut that.
Melissa, I know that you are a legal expert. You're not necessarily a political expert, but you do live in America and you know what's going on. When I first heard this, right, because I'm not a legal expert, I said this can only, one would hope, animate Democrats for the upcoming election. The debate was a disaster for Joe Biden. I mean, there's no other way. There's no sugarcoating it. But you would think that Democrats, especially in this moment, would not want a dictator or a dictatorship. And this may actually end up backfiring possibly for Donald Trump. I don't know. But what is your read on that?
So I actually went to talk to some voters for something else I'm working on this weekend. And I do think people understand that democracy is on the line. I think they understand that Donald Trump and a second Donald Trump presidency will not fail this time, that it will actually be successful in doing all of the things that it professes to want to do. And if you've read Project 2025, you know what the second Trump presidency seeks to do. And I think they're willing to take a knee on certain things. Like nobody I talked to was like, I'm out for Joe Biden. Everyone acknowledged that the debate was a real debacle, but they also said, if push comes to shove, I'm going to go with the stuttering guy over the guy who will not stutter when he's starting a coup. Mm-hmm. And, those aren't great choices. I think the debate was an unmitigated disaster, not for either party, although I think both Trump and Biden performed abysmally. I think it was honestly an unmitigated disaster for the American people. Like, there are really good candidates. We could do better on both sides of the aisle, which is not to say that Joe Biden hasn't been the most successful president in recent memory. He's done amazing things. And he's literally turned this country around after a horrible public health crisis. But that was not a great performance on Thursday night. And I think, that should be acknowledged. But I think most people are thinking about what is an existential threat to government as we know it, for society as we know it, and they're making their decisions with that in mind.
What do you think of the people, the hand-wringing and the folks who may be sitting on the sidelines saying, oh, you know what, Joe Biden should drop out, he should release his delegates at the convention? Are you in agreement with that?
I mean, I understand where it's coming from, because I think people are genuinely afraid of what the alternative is, and they're right to be afraid. Like, this literally could be the last election that we actually get to participate in a meaningful way. And I'm not being hyperbolic about that. I think that's right. If you read Project 2025, it's a frightening document with frightening repercussions if Donald Trump is elected. So I understand what's animating those discussions, but I think you have to be practical. What are the chances that we would be able to pull something like that off before November? What are the chances that we can do it in a way that is coherent and collectively focused so that it doesn't descend into a kind of chaos that makes the opening for Donald Trump even wider? I think all of those things are really important. And again, I don't have any answers. I'm a lawyer. I'm not a political analyst, but lawyers are practical people. We are about mitigating risk. And I think there are a lot of risks.
Yeah. Melissa Murray, it was a sobering conversation, but you're the perfect person to handle it and to talk about it. I appreciate you appearing here on the Don Lemon Show. Thank you. I hope to see you soon.
Thanks, Don.
Thanks for watching the Don Lemon Show. Make sure you click on the image in the top right to subscribe to my channel and the thumbnail in the bottom right to watch more content from my show. And I'll see you next time.